Ben Franklin's World is a production of the Omohundro Institute.
So we're walking into the rotunda of the Charters of Freedom now, and you can see that the ceiling is 75 feet tall. The purpose of this building really is twofold. One, to provide access to records for researchers, and that is the other side of the building. But we are on the visitor side of the building, or the museum of the National Archives. And this side is really to educate the public about the history of our country. So we have original documents on display. The other thing to notice in this room are these niches. I like to point these out because they're completely empty. The building was built in the 1930s, and it was during the Great Depression. So some corners were cut with the construction, and one of them was the sculptures that were supposed to be in those niches were never added. The number one question that visitors have is, why can't they take photos? And that's because we had a lot of problems with visitors who would say their flash was off, and their flash really wasn't off. And every time a document is exposed to even a little bit of light, it damages the document. The same question is why it's so dark in here. It's the same reason, because we don't want the documents exposed to light.
Hello, and welcome to episode 259 of Ben Franklin's World, the podcast dedicated to helping you learn more about how the people and events of our early American past have shaped the present-day world we live in. And I'm your host, Liz Covart. Law is all around us, and the basis of American law comes not only from our early American past, but from our founding documents. This episode begins our fourth Doing History series, a series dedicated to exploring early American history and how historians work. Over the next 4 episodes, we'll explore the early American origins of the Bill of Rights, as well as the history of the Fourth Amendment. The Fourth Amendment will serve as our case study, so we can more closely see where our rights come from and how they develop from the early American past. We'll also use the broader history of the Bill of Rights to explore legal history. Now, legal history is a specialized field of study, so we'll investigate how the history of the law differs from other historical subjects, and how lawyers and historians use and view the history of the law differently. So where do we begin? Our journey to understand American law begins in the United States' founding documents, because it's within those documents that we find the basis of American law. First, we have the Constitution, a document that defines the roles, powers, and different branches of the United States government. Second is the Bill of Rights, the first 10 amendments to the Constitution, which work to limit the power of the Constitution's government by guaranteeing individual liberties. Now, both the Constitution and the Bill of Rights are within the care of the United States National Archives. And luckily for us, Jessie Kratz, the first historian of the National Archives, has invited us to come view the Constitution and Bill of Rights in the rotunda for the Charters of Freedom. She's also agreed to take us back to her office, where we can talk about the history of these documents and the work the National Archives does to care for them.
And this is the Constitution. So originally, when we got the Constitution and the Declaration of Independence from the Library of Congress in 1952, and we had already had the Bill of Rights, the first 2 pages of the Constitution were on display, as well as the Bill of Rights, and then the Declaration of Independence. You had to climb upstairs in order to view the documents, and in order to make the rotunda more accessible, between 2001 and 2003, we renovated the exhibit cases, and now we have all 4 pages of the Constitution on display. They are probably the most important document in our federal history. Originally, when the rotunda was designed, John Russell Pope, the architect, didn't have in mind that he would be displaying the Bill of Rights in here. The Bill of Rights sort of became an afterthought. Sometime between 1938 and 1952, we decided that the Bill of Rights was important enough to go on display as a charter document.
So we're here in an office at the United States National Archives with Jessie Kratz, the first historian of the National Archives. Jessie, thank you so much for taking the time to help us explore the United States' founding documents. Now, I wonder if we could begin our exploration with the pantheon of the United States' founding documents. What exactly does that pantheon look like? What documents do Americans consider to be their founding documents?
So the documents that we have on display here at the National Archives, what we call our charter documents, the Charters of Freedom, because they were the ones that created our government, are the Declaration of Independence, the Constitution, and the Bill of Rights. They're on permanent display here, so they're on display 364 days a year.
I'm curious about our choice of documents, because we do have the Declaration of Independence, the Constitution, and the Bill of Rights, all of which the National Archives proudly displays. But there are other documents that were important to the founding of the United States that don't get displayed, like the Articles of Confederation, its first constitution, or the Treaty of Paris, 1783, which ended the war for independence and secured independence for the United States. Is there a definition you could share with us that the National Archives and the American people use to define what they consider to be a founding document?
Well, we do have those documents in our holdings, and we do display them every once in a while. We've had the Articles of Confederation on display, but they are an artifact of an old government, the government that's not our current government. And so the Constitution itself, which I would say is front and center, is the backbone of our entire government. Every law has to be consistent with its provisions. The Declaration itself, it was the mechanism of us earning our independence from Great Britain. And the Bill of Rights is part of the Constitution. And it's the part that most people are probably familiar with because it outlines the individual rights that affect them as individuals.
It's really interesting, don't you think, that when we Americans talk about the foundation blocks of the United States, we're always turning to texts and documents. What do you think it is about documents and texts that we Americans find so fascinating? Why do you think we put so much stock into texts and words?
Well, I think it's because you can actually see the piece of paper that someone held, that someone read, that someone created. If you go into the rotunda, you can see the Constitution. You can see that it was signed by George Washington and Alexander Hamilton. If you look at the Bill of Rights, you can see that it's signed by Frederick Muhlenberg and John Adams. And in particular, the Declaration, if you could read it, if it wasn't quite as faded, you can see John Hancock's signature, which is what's synonymous with signatures.
Now, the rotunda for the Charters of Freedom does display the Declaration, the Constitution, and the Bill of Rights. But we came in today specifically to look at the Bill of Rights. So could you tell us about the Bill of Rights as a document and about its creation?
The Bill of Rights was created in 1789. It was penned on September 28th, 1789, by clerks of the House and the Senate. It's on parchment. It is written in iron gall ink. If you come to the National Archives and look at it, you can see that it has all 12 amendments to the Constitution on it. There are 2 that weren't actually ratified. And then you can see a number of signatures at the bottom of the document. It's the joint resolution proposing amendments to the states. And that's the function it served. It was saying that this document was legitimate, that Congress passed it, and they wanted the states to ratify these amendments.
I noticed during our tour of the rotunda and just now that you called the document the joint resolution proposing amendments to the states. But we really do know this document as the Bill of Rights. When did we come to know this joint resolution as the Bill of Rights?
Well, originally it was just referred to as a joint resolution of amendments or the amendments to the Constitution or articles of amendments to the Constitution. And I don't believe that anyone really referred to it the Bill of Rights consistently until really the 20th century. By the time we got the document in the 1930s, it was called the Bill of Rights pretty consistently, but it's something that evolved over time.
Now, history credits James Madison with writing the joint resolution to the states, what we know is the Bill of Rights. How did Madison come to draft this joint resolution?
James Madison was considered the principal author of the Constitution, and he was very much against the idea of adding Bill of Rights to the Constitution or adding any amendments. And this is because he really had a vested interest in maintaining the structure of the Constitution that he worked so hard to create. So when he ran for Congress, for the very first Congress, his constituents in Virginia were very much in favor of having a Bill of Rights to the Constitution. So he had a sort of promise that he would enact some sort of Bill of Rights if he made it to Congress. And so he subsequently was elected, and he proposed amendments to the Constitution that were really rights related. There were a lot of amendments during the ratification process that states proposed that would fundamentally change the structure of the Constitution. He did not want that to happen. So he proposed amendments into Congress and eventually kind of steered them through. The House passed a number of these, 17 actually, and then they went to the Senate, and the Senate consolidated them and sort of changed some of them to make them 12 amendments. And that's the 12 amendments that you can see on the document today.
But the states only ratified 10 of the 12 amendments Congress sent them.
Yes, originally only 10. The bar was you had to have 3/4 of the states. So when the document went to the states for ratification, we only had 11 states. North Carolina and Rhode Island hadn't yet ratified the Constitution. But over the ratification process, which was, over a year and a half, North Carolina, Rhode Island, and Vermont all entered the Union. So the bar was 11. So once 11 states ratified any number of amendments, they became part of the Constitution. So when Virginia ratified 3 through 12 on December 15th, 1791, those amendments became part of the Constitution. And the first 2 originally just fell to the wayside.
Is the copy of the Bill of Rights on display at the National Archives the only copy Congress produced of its joint resolution, what we know as the Bill of Rights?
No, it is not the only copy. In 1789, and September 28th, the clerks of the House and the Senate, they drafted the one you see in the rotunda, which is the joint resolution, the official version. And then they wrote 13 additional copies. They were for the 11 states that existed at that time. And then the 2 states, Rhode Island and North Carolina, that had yet to ratify the Constitution. And then George Washington sent those original copies to the states for ratification.
So if Congress created 14 copies of the Bill of Rights, what makes the copy on display at the National Archives the Bill of Rights? Why is this particular copy so important?
That is the original joint resolution passed by Congress, and that is the Bill of Rights. The subsequent copies were, even though they were done at the original time, they were meant to just communicate to the states that this is what we did. Fortunately, most states still have their copies of the amendments, and so you can still see very similar versions of what we call the Bill of Rights in their states as well.
As we think about historical documents and archives, how do archives really make the decisions that they do to say that this particular copy of the joint resolution is the Bill of Rights and is therefore different from and not equal to the other copies produced by Congress and sent out to the individual states? How do archives like the National Archives determine, the hierarchy of documents and their significance?
Well, the difference between the version of the Bill of Rights that we have in the states is that our version is a federal record. It's the version that was maintained by the State Department. And before the National Archives was created, the State Department was in charge of maintaining and preserving official records of the government. So that version is a federal version. The ones that went to the states became just state records, except one notable exception is Delaware's copy of the Bill of Rights. They actually ratified the Bill of Rights on the document itself that we sent them, affixed their state seal, and sent it back to Congress. And so that record is also a federal record, and we have it here at the National Archives.
It's interesting to think about the lives of documents. We know from speaking with other scholars in earlier episodes that documents and objects have stories to tell us. So what about the physical life of the Bill of Rights? After Congress passed the joint resolution, wrote it up, and the states ratified 10 of the resolution's 12 amendments, what happened to this official document?
So the Bill of Rights story is very similar to the early story of the Declaration and the Constitution, but at some point in time, their stories diverge. The Bill of Rights was created in New York in 1789. And then when the government moved to Philadelphia in 1790, it went with the government to Philadelphia, and it was probably folded up and stuck in some file cabinet. When the government moved to D.C. in 1800, again, it was taken out and shipped down to Washington, D.C. The only time it left D.C. when it was in the custody of the State Department was during the War of 1812. And when the British burned Washington, a very quick-thinking clerk from the State Department was able to round up all the original historic documents of the government, so the Constitution, the Bill of Rights, and the Declaration, and they actually took it out to Leesburg for safekeeping until the British had left the city. After the burning of Washington, the document was brought back to the State Department, and then it traveled around D.C. as the State Department moved offices over the course of their history, and eventually ended up in the old Executive Office building. And that's where it was when we got it in 1938.
So the Bill of Rights, Declaration, and Constitution weren't documents that people just looked at on a regular basis like we do now. It sounds like the government had them and put them away in a filing cabinet and really only looked at them when the State Department changed offices.
That's correct. The Bill of Rights, and then, unlike I said, the Declaration and the Constitution, at some point in time, they were pulled out, and the Declaration was put on display for most of its history, and then it was sent to the Library of Congress in 1920. The Bill of Rights and the Constitution were sort of filed away and forgotten about.
So how did the National Archives come to possess and become the caretaker of these founding documents? Could you tell us about the founding of the National Archives?
The legislation to create the National Archives originated in 1926, and it was called the Public Building Act. And Congress wanted to revitalize this area of Washington, D.C., and create new government buildings for the expansion of the government bureaucracy. And so one of them was to be an archives. The archives originally was slated to be on the ground where the Justice Department sits, but John Russell Pope, our architect, he thought symbolically that this location was more important because it's halfway between the Capitol building and the White House, and that's where the records that were originated that would come to the National Archives. So we were eventually created in 1934, and we were given the task of maintaining the permanently valuable records of the federal government. So our tasks were really to go out to all the federal agencies and all over the city and all over the country and look through their records and do inventories and find out what's deemed valuable enough to become a permanent record at the National Archives. And that's what we did. Originally, when the building was being built, there was a cornerstone laying ceremony. And Herbert Hoover, who was the outgoing president at that time, it was 1933, early in the year, he mentioned that the Constitution and the Declaration would be coming to the National Archives. And in fact, he put copies of the Declaration and the Constitution in our cornerstone of our building. The Library of Congress owned those documents at the time, and they were not willing to relinquish them to us. So over the course of the next 15 years, we acquired the historic records of the State Department, so the Bill of Rights and other amendments and things like the Emancipation Proclamation and other executive orders. But the Declaration of Independence and the Constitution remained at the Library of Congress until 1952, when Congress themselves told the library that they had to send them here to the National Archives. And they actually arrived 2 days before Bill of Rights Day in 1952, and they were put on display on Bill of Rights Day in 1952.
Why did Congress make that decision? Why did it matter that the Constitution and the Bill of Rights and the Declaration of Independence should all be in the possession and under the care of the National Archives and not the Library of Congress?
Well, one of our missions really is to be a complete and accurate history of the federal government. And those were two of the most important documents in our federal history, and not having them here would be a huge omission in our, record.
You mentioned that when Congress created the National Archives, archivists went all throughout the government departments to judge whether documents were valuable enough to be part of the National Archives. Now, it's a pretty safe bet that the Declaration, Constitution, and Bill of Rights were really important documents. But do we know how the archivists made that call? How did they know whether a document was valuable enough to be maintained permanently in the National Archives?
There was actually a form that they filled out that had specific questions about the documents, but it's easiest to think about 1% to 3% of what the federal government creates today becomes a permanent record, which really isn't that much. I mean, in the end, since we have 15 billion pages, it is a lot of material, but when we're talking about what the federal government does, it's not a lot. You think of it as, is it a document that documents the rights and entitlements of the citizen? Does it document the history of our federal government? Does it shed light on official government decision-making? These are the documents we're looking for that come to the federal government. Is it the only version? Is it the final version? Those are the kinds of things that we want to see here.
Okay, so once a document like the Bill of Rights is judged by a government archivist to be really important to the federal history of the United States, what happens to that document when it comes into the care of the National Archives? How exactly does the archives preserve all these documents so that future generations can access and use them?
Well, the Bill of Rights and the Constitution and the Declaration are very different than the way we normally house our documents. Since they're on permanent display, we have to keep them in the state-of-the-art cases and monitor their temperature and monitor their humidity constantly. But we do that on a smaller scale with the rest of our documents. When they come to the National Archives, we make sure that they don't need any conservation treatment, that they are placed in stack areas that are temperature and humidity controlled, perform holding maintenance on them to remove anything that might be harmful to documents. So sometimes we'll go through and remove staples or paper clips or anything that might damage a document. And then they're made available to the public. And when we make them available, we're very strict on what you can do with the records. We do make the originals available to people. They just have to be very careful that they keep them in the correct order, and that obviously that we don't give them opportunity to steal our documents.
But what about the Bill of Rights, Constitution, and Declaration? Given these documents are key to the founding of the United States, what is the process of preservation like for these documents?
So the Bill of Rights, its conservation history is very thin. We don't know what happened to it before it came to us. We took it out of its original binding and put it on display. And then once it went into the cases in 1952, no one touched that document until it came out of the cases in 2001. And that's when our conservation staff, these cases have been closed for 50 years, and they had no idea what was going to happen when we opened it. So when they opened the cases and took the documents out, they were able to do minor cleaning of the documents in just the places that there wasn't any text. And they do conservation on the edges of the document. So if there was any small tears, they replaced it with a little bit of Japanese paper in order to make sure the document won't get caught on anything. And they did a little bit of removal of some of the adhesives that were remaining from when it was bound by GPO. The Government Publications Office But that's pretty much what they've done to the document. And then it went in the cases in 2003, and we will not open it for 100 years.
So what are the logistics of permanent display like? Because you mentioned that the Bill of Rights, the Constitution, and the Declaration of Independence are in permanent display at the National Archives. So how can the archives protect a document from light, air, and moisture if it's always on display?
So the cases that currently house our charters are state-of-the-art cases designed by the National Institute of Standards and Technology. They have only the highest quality of metal. We constantly measure their temperature, their humidity, the pressure of the documents to ensure that nothing is happening in the case that can damage or deteriorate the document. They're on permanent display, and the only days that they're not on display is Christmas and Thanksgiving. But every day they go on display, and visitors can visit them from 10 in the morning until 5:30 at night. So every night they go back into their vault here. So they come out of their vault every morning and they go back every night. But just to point out, no one actually touches these documents. It's all automatic, and the documents are sealed in its cases. So no one is actually physically handling the documents themselves.
Do we know who visits the Declaration, Constitution, and Bill of Rights? Do we have any idea about who comes to visit these documents and why they come to visit them?
So we have roughly 1.3 million visitors a year to the rotunda of the National Archives. And I think it's important because it shows that these are actually things that happened. The Declaration actually happened, that this Constitution exists. So I think it's also an idea of like a pilgrimage. Everyone who comes to Washington, D.C., if you ask them where they're going to go, they say, I'm going to go to the National Archives to see the Declaration and the Constitution and the Bill of Rights.
What if we'd like to become one of these roughly 1.3 million visitors who come to the National Archives? How can we visit the National Archives, and how should we plan our next visit?
Yes, the National Archives is open, like I said, 364 days a year. We're open from 10 to 5:30. We're really busy during the Cherry Blossom Festival. So basically from March through Labor Day are our busiest times. So I would say come in the off months. But also we do allow reservations. Reservations are free. You just have to go to our website, museum.archives.gov, and make reservations. And we also have docent-led tours at 9:45 in the morning. So if you really wanted to see these documents, I would recommend that you went to our website and made a reservation to have a docent take you around before the building actually opens.
We're looking at the Bill of Rights. Technically, it's the joint resolution proposing amendments to the Constitution. It proposed 12 amendments to the states because that's the 12 amendments are what Congress passed. If you look at it, you see that it's not quite straight. It's parchment paper, so it's cut. You can see that it's tabbed in order to lay flat. The document itself was signed by Frederick Muhlenberg, who was the Speaker of the House. And you can see down here, John Adams, who was the President of the Senate, because he was Vice President. And then the Clerk of the House, John Beckley, and the Secretary of Senate, Samuel Otis, signed it in the corner. The document itself is very faded. It's hard to read the text. So as I point out here, you can barely see where John Beckley signed it and Samuel Otis signed it. The signatures of Adams and Muhlenberg are much more pronounced.
Part of the mission of the United States National Archives is to create the most comprehensive and accurate record of the United States federal government. Now, this is not an easy task. As Jessie related, the federal government generates hundreds of millions of pages of documents each year for the National Archives to sift through. But sift through these different pages, the National Archives does. And as it sifts through them, it asks questions of each document. Do any of these documents detail the rights and entitlements of the citizen? Do they detail the history of the federal government? Do they shed any light on the government's decision-making? Is this just a one-of-a-kind document? If the answer is yes to any of these questions, then the National Archives considers adding the document to its permanent archive. Now, the founding documents of the Declaration of Independence, the Constitution, and the Bill of Rights meet all of the archive's different criteria for determining an important archive-worthy document. Plus, they're the United States' founding documents. What makes the founding documents is that these documents serve as the backbone of our entire government. The Declaration of Independence created the independent nation of the United States. The Constitution established the United States' government. And the Bill of Rights, well, that imposes limits on the power the federal government can exercise over its people. The words and ideas contained in these documents are really important, which is why the National Archives devotes so much time and care to preserving these documents while also making them available for all to see. Now, as Jessie mentioned, documents serve functions. And our conversation with Jessie really helped us better understand the broader functions of these founding documents, especially the function and purpose of the Bill of Rights. Now, when Congress created the Bill of Rights in 1789, it didn't really create the Bill of Rights. It created a joint resolution from Congress to the states, and its function was really to serve as a notice and request from Congress to the states that the states consider and ratify amendments to the Constitution. But once the states ratified 10 of the 12 amendments in Congress's joint resolution, the purpose and function of the document changed. The joint resolution to the states went from functioning as a notice and request to the states to functioning as a Bill of Rights. So, what does this mean exactly? What does it mean for the Bill of Rights to function as a Bill of Rights? As I mentioned at the start of this episode, this Doing History series is dedicated to exploring the early American origins of the Bill of Rights and the Fourth Amendment. We're exploring this document and its Fourth Amendment so that we can better understand our rights and the field of legal history. Law is all around us, and history plays an important part in the United States' legal system. So, the next step in our exploration should be to develop a better understanding of what legal history is, what it can tell us about the history of the United States and its legal system, and what functions historical documents like the Bill of Rights play in modern-day American law. Mary Sarah Bilder is a professor of law at Boston College Law School. She's also a historian, which means she can help us investigate aspects of both history and the law. Now, you may remember Mary from episode 107, when we spoke with her about her research on James Madison's notes of the Constitutional Convention. Did you know that Mary won several awards for that research? She published it in a book titled Madison's Hand, Revising the Constitutional Convention, and one of the awards she won was the 2016 Bancroft Award in American History. Mary is really the right expert for us to talk to, because she has such a great knowledge of both the law and the early American past.
The Bill of Rights itself measures a little bit over 28 by 30 inches. You can see it's not perfectly straight. It's made of parchment. We don't know what kind of animal parchment it is. We think that it's a calf because given the size of it, but we have not been able to do any testing to see on the exact animal that it's made of. The ink is iron gall ink, which was ink typical at that time. Parchment was standard at that time for all of our acts of government. So if you go look at the first, several years of documents, we used parchment for all. And I think that it is a sense that makes it the official version. It's the version that will be maintained forever.
Mary, we're hoping you can tell us something about the basics of American legal history and the role that legal history plays in modern-day American law. So we know the Constitution and the Bill of Rights are founding documents and historical documents. That these are the documents that serve as the foundation of the United States' government and legal system. But there are also something called living documents. So could you tell us what historians and lawyers mean when they refer to the Constitution and Bill of Rights as living documents?
Right. That's one of the most important aspects of what we think of as an American Constitution, is that the Constitution has within it the ability to adapt over time. And it does that in a variety of ways. One way we might think about it is that we consent to the Constitution through the preamble. So when you were a young child in school, you might have had to memorize the preamble, and the preamble begins, "We the people." And it doesn't say "we the people of 1787 or 1789, it says "we the people now." And so in that sense, every time we memorize the Constitution, we bring it into our own time. But then we can also think about the way in which the Constitution lives on through the fact that it's amendable. So the Constitution can be amended. And then the Constitution can be interpreted both by Congress and by the courts. And particularly when the Constitution is interpreted by the courts understand that they want to have the Constitution work for us today. One of the most famous early Chief Justices, Chief Justice John Marshall, said this in a very important opinion, McCulloch v. Maryland. And in that opinion, he wrote, "It's a Constitution intended to endure for ages to come, and consequently to be adapted to the various crises of human affairs." And the court really takes that to be the way they are supposed to understand what the Constitution is about.
Is the fact that the Constitution, the American Constitution, is the fact that that's a living document unique to the United States, or are all constitutions living documents?
Well, some countries don't have written constitutions. So a great example is Great Britain. Great Britain always thought it had a constitution, but they have a constitution in what we consider to be an older sense, as referring to all of the important concepts and institutions that make up the history and governance of England. And at the time that our Constitution was written, that's what people mostly thought the word Constitution meant. But because the Americans needed to change that, they ended up writing down on pieces of paper what they thought the system of government should be. And over time, the word Constitution became associated with that written document as opposed to really referring to sort of a system of government. And so the American Constitution, in some ways, draws on this older understanding of Constitution as a system of government, while also including this modern notion of being a written Constitution. And around the world now, the American, let's call it a genre of a written Constitution, has become very influential. But if you study comparative constitutionalism, that is the history and way that all constitutions work, you'd see that people have written constitutions, but they mean very different things in different countries in terms of how tightly they control the way the government operates.
I really liked how you used the word genre there, because it doesn't sound like one type of method of constitutions is necessarily better than the other. They're just different and have slightly different historical contexts.
Yeah, they're different. And one of the really interesting things about the United States is the United States Constitution, is basically the oldest national or federal constitution in the world. But that's in a funny way just because it happened to be the first one. And it's very unusual in having survived a very long time. But it survives in part because however much we think about it, we do tend to allow our institutions to interpret it in ways that make it continue to work in modern times.
Now, you mentioned the history of constitutions, which is a history of the law. As you are both a historian and a lawyer, someone who works in both the fields of history and the law, could you tell us what historians and lawyers mean when they talk about the history of the law?
Right. So the history of the law, Liz, could be understood quite narrowly. So we could let's talk about the history of property law or contract law. And that would be a pretty narrow story about how particular legal rules developed. But what I'm interested in, and what a lot of people are interested in terms of the history of the law, is the history of law in a sense of law representing power and authority and governance in the United States. And the United States, in some ways, is interesting because early on, at the time of the Revolution, many people began to imagine law replacing royal authority or the king. So Thomas Paine famously said in Common Sense, in America, the law is king. And if you think about it that way, then the story of the history of law is also the story of the history of the United States, because law is so foundational both to the way our government operates, but also to the way sort of we culturally understand ourselves. So we're a nation which often frames problems in terms of, in some ways, thinking about it through a legal lens. And so that's why the history of law is really quite interesting, because in some ways it's really the history of our country.
What about the ways that historians and lawyers look at and use the history of the law? Do historians and lawyers look at the history of the law and think about it and use it the same way, or do they think about this history and use it differently from each other?
Yeah, great question, Liz. I think lawyers tend to use history more functionally, and that's because lawyers represent a client. So for lawyers, history serves a function where it helps you develop an argument for the solution your client wants. When historians look at what happened in the past, they don't have a client. And so they're trying to understand the past. So a lawyer might look to the history of a particular law to try and explain, well, why should that history continue to apply to the client or should be abandoned? Whereas a historian would ask questions about, well, why did that law come to be? What does it tell us about who was included at that time? What might be ways that we understand how people in the past thought? So they have different purposes in what they're asking.
So how can studying the history of the law, combining both the legal approach of working for a client and the historical approach of just looking for context and how and why people of the past acted. How can combining these two different approaches help us better understand the history of the United States?
Well, I think the history of the United States in many respects is really about power. And so the history of law is the history of how and who has exercised power in the United States. And in that sense, it's a story about remembering our past and beginning to question our past. One of the figures in history mythologically that I love is Cleo. And Cleo was the muse of history. And she was actually the daughter of Zeus and one of the Titans, Titan Mnemosyne, who was the Titan of memory. And in this sense, when we do history, we're really studying the memory of power. And that's particularly true for the history of law.
Now, looking at just the law for a moment, when we talk about law, we tend to talk about constitutional law and statute law. What exactly are we referring to when we say constitutional law and statute law?
Yeah, so constitutional law are the rules that are set up in the Constitution, and that includes both the Constitution that was written in 1787 and then the amendments that have changed that Constitution. And statute law is law that is enacted by Congress, and it needs to be authorized by the Constitution. That is, it can't be outside of the scope of the Constitution. And we talk often about a hierarchy of law. So the Constitution's on the top, and Congress is below that in terms of passing federal laws. And then we can also talk about statute laws and constitutional laws in the states, because the states also have constitutions and statute law, and they mirror that with the Constitution being on the top hierarchically and statute law being below it. So an example of this would be, given that this is going to be the 100th anniversary soon of the 19th Amendment, is the Constitution has an amendment that says that people can't be disenfranchised on account of sex. And this is what allows women to vote beginning in 1920. But in and of itself, that didn't allow all women to vote. So very importantly, for example, women of color were often disenfranchised because states still had laws, for example, literacy laws, that were used to bar them from voting. So only in 1965, when Congress passes a statute, the 1965 Voting Rights Act, does the 19th Amendment really begin to be effective for all women in the United States. And it's a nice example of how the Constitution and statute work together to give us the rights and the way we're able to exercise our ability to participate.
So it sounds like the Articles in the Bill of Rights fall under constitutional law, and then the laws that further define those articles, those laws are created and passed by Congress, so they're statute laws.
Right. So the Bill of Rights are just our first 10 amendments to the Constitution, and they're not even called the Bill of Rights generally until around the time of the Civil War. And then that concept of thinking about the amendments to the Constitution, the first ones to the Constitution as the Bill of Rights, is really a product of the 1940s and the latter part of the 20th century.
Mary, you noted that the United States is a nation with a federal constitution and a federal government and many state constitutions and state governments. How can there be both one federal constitution and many state constitutions? How do all of these different legal bodies and documents work together?
Yeah, it's a great question, Liz. It kind of goes back to the very beginning of what we think of as the United States, that in the beginning, the entities that we think of as states and the national government were part of Great Britain. And at the moment of independence in 1776, those different governmental structures took on new names. So we have entities that we call states. I grew up in Wisconsin. I don't know where you grew up, but I'm now in Massachusetts. And we have, obviously, the United States, which is the collective of all of those states and other places, like, for example, Puerto Rico or the Virgin Islands, that have a different status. And each of those entities is governed by a document that we call a constitution. Some of those constitutions actually predate our 1787 Constitution. So, for example, Massachusetts has a constitution that dates back to 1780. And although it's been amended, it's never been completely revised. So here in Massachusetts, we like to think we have the oldest continuous constitution. New Hampshire has one that dates back to 1784. But all the rest of the state constitutions post-date the 1787 Constitution. And some constitutions have been rewritten many times. So, for example, Georgia is on its 9th constitution, a constitution that was technically ratified in 1983. So each state has a constitution, and then the U.S. government as a collective has the constitution that we think of as the Constitution itself. So you can imagine that we could have a relatively flat arrangement where, for example, all the states had the highest authority and they had to agree together on what to do. In some ways, that was the Articles of Confederation, the first constitution that governed the United States right after the Revolutionary War. In 1787, when the Constitution that we think of as the Constitution was written, they included a phrase called the Supremacy Clause. And what the Supremacy Clause does is it makes the U.S. Constitution supreme, or at the top of the hierarchy. And all state courts and state legislatures are bound by it. So it creates a hierarchy between the 1787 federal constitution and then every state constitution.
So the federal constitution and federal laws are supreme over state constitutions and state laws, thanks to the federal constitution supremacy clause. Now, I'm curious to know how the structure of federal supremacy came into play when the states ratified the Bill of Rights in 1791. Did the states just willingly accept all these restrictions that the Bill of Rights imposes on government power?
Well, for the first probably 60 years, the amendments didn't really mean very much to most people. They were tacked onto the Constitution, but they weren't the part of the Constitution that anybody worried about. And in fact, in the 1830s, the Supreme Court made clear that you couldn't use them if you wanted to complain about what the states were doing. So there was a very famous case involving a person named Barron. He was mad at the city of Baltimore. He thought the city of Baltimore had done something to his property. He tries to argue that the Fifth Amendment of the Constitution basically bars Baltimore from doing this. And John Marshall said, no, the amendments only work against the federal government. And for most Americans in the early 19th century, the federal government doesn't affect your life. And so the amendments basically aren't used. At the time of the Civil War, people began to argue around the adoption of the 14th Amendment that maybe the states should also be bound by what the amendments required. And some people believe that the 14th Amendment's language was intended to incorporate that in what we call the Privileges and Immunities Clause. In any case, in the immediate aftermath of that, the court slowly begins to, one by one, take rights out of the Bill of Rights and say they apply to the states. And that's a process we call incorporation, but most incorporation happens in the 20th century. And so the world that we live in, where when government does something to us, we can complain about, that's a product of actually often decisions by the Supreme Court in the 1920s, 1930s, and 1960s that allow us to sue the states using the Bill of Rights. Prior to that, the Bill of Rights was nice to read, but it wasn't very effective in courts.
That's really interesting. And it does tell us something about the history of law and power and authority in the sense that early on there were these rights that Americans had, but they didn't really pay attention to them. You know, they just had these rights and they were nice to have, but then at some point around the Civil War, it sounds like Americans started paying attention to their rights as they were outlined in the Bill of Rights.
Yeah, it's a really interesting fact, Liz, about the way that our understanding of the Constitution has changed over time. In the beginning, constitutions were important, but they were important to set up a system of government. Over time, the fact that they set up a system of government remains important, but we tend to think of the Constitution in some ways as something that we use to litigate, to decide questions about our contemporary life. Is this a First Amendment right? Is this a right that a criminal defendant ought to have? Is this something about equal protection? But it wasn't clear to everybody in the late 18th century that that was what one did with rights. Walk into court and say, hey, I have this right, and then the government's doing something against it. A lot of people thought what was good about rights was you put them in a constitution, and then everybody in the public knew that they had them, and then they could make them effective through ordinary political means. For example, by yelling at your legislature or your Congress about what they should do. So the way we think about rights in a very legally actionable way is really a pretty recent development.
Now, the Supreme Court is an entity that has come up several times in our conversation. And earlier you noted how in the 1830s, Chief Justice John Marshall said Americans couldn't use the rights in the Bill of Rights to sue the states. But that over time, between the 1920s and 1960s, the Supreme Court gradually changed its ideas about our rights and how we could use the Bill of Rights in court. So, the Supreme Court. Would you tell us about the court and how a case makes its way to the Supreme Court?
Yeah, so today the court has 9 justices, and we see them a lot. They do a lot of public speaking. Sometimes they appear on Sesame Street. They give talks. A thing that people often don't know is that the only thing the Constitution tells us about the Supreme Court is that there should be one Supreme Court. So the Supreme Court is the sort of most underdeveloped part of our government in the 1787 Constitution. It shows up in Article 3, which is the shortest article. And most of how we come to understand the court is itself a product of history. So a fact I love is the first Supreme Court, when Congress created the first Supreme Court, there were only 6 justices. There were an even number of justices. And nowadays we think, oh, you have to have an odd number of justices because we are used to thinking of the court as being divided 5-4. But that wasn't how Congress imagined the Supreme Court in the beginning. They imagined the Supreme Court as being an even number of justices. So a lot about the role of the Supreme Court has changed over time. In the beginning, the Supreme Court justices had to ride circuit. They rode on horseback down to South Carolina, for example, and Georgia to hear cases. Over time, the federal judiciary became large enough that the Supreme Court could do what it does today, which is it sits in Washington and just decides cases there. And in fact, the Supreme Court didn't even have their own building until the 20th century. Before the 20th century, the Supreme Court heard cases in Congress. Their quarters were basically in the Capitol. And when Chief Justice Taft became Chief Justice, he thought they should have a building. He had previously been president, so he was used to a world where there was the White House for the president and there was Congress had its own building, the Capitol, and he thought the court should have its own building. So Chief Justice Taft is the one who designs the building that we have today as the Supreme Court. So that makes the Supreme Court suddenly look like a real important third branch. But that's also just a product of our history. So a case can get to the Supreme Court by 2 different paths. The first path is it can come up through the federal court system. And the U.S. government has a set of federal courts that sit in a series of what we call circuits across the United States. And a case could come up through the federal district court to the federal circuit court and then to the Supreme Court. But alternatively, there's a second path. A case can be heard through a particular state's court system all the way up to that state Supreme Court. And then if the state Supreme Court decides an issue of what we call federal law, a question that relates to a federal statute or a treaty or the U.S. Constitution, a person can appeal or complain about that to the Supreme Court. And the U.S. Supreme Court also hears cases about federal and constitutional law that have been previously decided by the state Supreme Courts. And this is why then the Supreme Court, the U.S. Supreme Court, becomes arguably supreme across both the federal court system and the state courts with respect to federal law.
And what is the process of the Supreme Court? Once a case reaches the court, How does the court hear a case, and what happens once the court renders a decision on the case? How are the decisions of the Supreme Court implemented?
The court has many people asking to hear its cases. Something like, I think, 7,000 petitions are filed or writs of certiorari asking the court to hear its case. Nowadays, the court has a mostly discretionary docket. What that means is the court mostly can pick which cases it wants to hear. And out of the 7,000 or so cases that people ask the court to hear, the court hears a very, very small number. They listen to oral argument in approximately 80 cases. Last term, I think they heard 69 cases. So an incredibly small percentage of cases get heard at the Supreme Court. And the Supreme Court then asks people to write briefs, to give explanations in writing about which way the case should go. And then they hear oral argument. Lawyers argue in front of the court, and the justices get to ask questions. And then they write an opinion, and that opinion then says to the lower court, the lower federal court, or the state Supreme Court, here's what the law is. Here's where you went wrong or you went right. And what's interesting about the system, the reason that they can be effective by only hearing, 70 out of 7,000 cases, is that whatever rule they say the law is, that binds every other court. And binds is just a fancy word for saying everybody has to follow it. And so in essence, they can pick one case, and by deciding that one case, if there are a bunch of other similar cases, then every other judge is going to have to say, oh, well, the Supreme Court said this. Now that's the rule we're going to have to follow.
Wow. That makes the Supreme Court's rulings really important, because when it rules in one case, that ruling really impacts a lot of different cases. Is this the role that the Supreme Court is supposed to play in our legal system? Is that how it's supposed to interpret the Constitution and the Bill of Rights, by hearing one case to rule on many cases?
Well, what the Supreme Court does in interpreting the Bill of Rights and the Constitution is they make it relevant to our own time. If we were sitting as historians, we could just have a really interesting discussion about the Bill of Rights and where did it come from. And if we were maybe English professors, we could sit around and think about the language and the wording. But as lawyers, what the purpose of the Bill of Rights and the Constitution is to help us decide specific legal cases, basically to problem solve for the current world. And so what the court does is they read the Constitution, they look at the history of those words, they try and understand how the court itself has understood things, they try and understand how things have changed, both with respect to the Constitution's amendments and to the way we interpret the Constitution. And then they try and apply it to whatever particular problem they're facing today. And the court, therefore, is very important in keeping relevant a document that with words that were often written many, many years ago. In some ways, I always think it's almost like a little bit like clothing. We might still say we wear shirts and pants, but those have changed over time from the way we might wear them in the 1780s.
You mentioned earlier that historians and lawyers both study the history of the law because it not only tells us something about the history of the United States, but it also really shows us the evolution of power and authority within the United States. Now, when historians study the history of the law, and really any and all aspects of history, they rely on different historical sources and documentation. So I wonder, what kinds of sources and documentations do lawyers, judges, and justices use when they study the history of the law? Do they study the history of the law differently from historians?
So this is a quite controversial issue at the moment. The Supreme Court, when it argues over what does some constitutional provision apply today, some justices use an approach that I would just call kind of classic constitutionalism, where they're interested in the history, but they think about the structure, they think about how has the court understood those provisions, what might we think today about those provisions. They incorporate a whole broad set of considerations. And some justices and some scholars argue that instead what the court should do is follow an approach that is labeled originalism. And originalism has changed a lot over the 20, 30 years that it has sort of been in existence. And what it does is it says you should try and figure out how people thought at the time about the words used. And prior to the invention of computers and digital technology, that was pretty hard. You had a limited number of sources to look at. Now, with the advent of digital databases, some lawyers argue that what we should do is go through those digital databases and look at how many times a word is used and try and figure out what might be the meaning of that word simply by looking at the frequency of use or the little tiny places in which the word is used. That's very different than what a historian would do. A historian would be interested in where words were used, but they would be more interested in the range of meanings a word had, in understanding the context of that word. Originalists tend to be more interested in narrowing the range of meaning and trying to argue, no, that word means only one specific thing. But most lawyers who argue in the Supreme Court are not originalists in that sense. They're interested in the history, but they're interested in making an argument that's much broader than just the historical origins of the concept.
Now, you said originalism developed 20 or 30 years ago. Do we know why it developed?
There's been a lot of work on the history of originalism. Many scholars date the beginnings of what we think of as modern originalism to the presidency of Ronald Reagan, that it was part of a broader conservative movement, particularly associated with Edwin Meese, who was then Attorney General, and Justice Antonin Scalia, who was a sort of young lawyer at that time. He was involved in these early places. And in the beginning, most historians of originalism suggest that the people around President Reagan and Attorney General Meese liked originalism because they thought it might provide a way to constrain courts. Over time, the way that that early originalism was explained was shown to be extremely problematic. So the very first originalists argued that we should think about the history of the people who were just inside the room framing the document. And that's a quite narrow group of people, and it's quite obvious that it's almost impossible to figure out what their actual intention was. And over time, originalists began to re-explain what they were doing. And now most, but not all originalists argue that originalism involves believing that the Constitution has a fixed, knowable meaning as of the moment it was written and ratified. And so what originalists try and do is they try and ascertain that precise meaning. And that's a somewhat simplistic way to explain what many people have written many articles about, but that's sort of the gist of it.
So how do these interpretations, classic constitutionalism and originalism, work in action? Say you have a case in front of the Supreme Court and a classical constitutionalist and an originalist go in to argue before the justices. Say it's a Fourth Amendment case. How do their different viewpoints inform how they would interpret the Fourth Amendment?
Yeah, so in the Supreme Court, one doesn't really see this in that striking a way. Both parties aren't about to risk their case by adopting one or the other controversial methodology. So instead, what you'd see in the Supreme Court is lawyers doing what lawyers do very well, which is putting forth all the various arguments that help their client. And where you tend to see these kinds of arguments come up are in briefs by other people to the court. So the Supreme Court allows people to file a brief, that's just a piece of paper with a written argument, as what's called an amici curiae, a friend of the court. And that's where we really see these arguments put forth most strongly. So somebody files on one side or the other a brief that says, hey, Supreme Court, I am a historian or I'm a lawyer and I'm going to tell you what the history of this particular concept is. And you could write that history. Some historians participate in that and they write that history in a kind of broad contextual way. And other lawyers or historians more inclined to originalism write that in a much more semantically focused way. So they are like, here's what this word meant. Here's 3 times we've seen this word. And now there's people who even basically are trying to, use word frequency. Here's all the written documents that were ever prepared in this point in time, and we can search those and come up with one specific meaning. The court tends to not want to make decisions on that ground, but occasionally it does. So many people believe, for example, that the Heller decision, which was a Second Amendment decision that altered the Supreme Court's understanding of the Second Amendment, that Justice Scalia, when he wrote that, had a originalist approach to his interpreting what does to bear arms mean. And Justice Stevens and others argued he had the wrong history, that the history had to be read in a larger context. But many Supreme Court cases don't involve history at all.
It sounds like lawyers and judges need to be both legal experts and really, to some degree, historical experts too.
Yeah, luckily they don't have to be historical experts because then we'd have a pretty small judiciary. What they need to do is they need to be good at listening to the arguments that lawyers put before them. And historians don't even get to show up in court. What historians do is they write books and they write articles, and sometimes they serve behind the scenes to help lawyers. And the lawyers take that historical information, that background, but then they use it in the particular language that lawyers speak to sort of argue to the court.
So there really is a collaboration between history and the law.
Yeah, a lot of times people read books. One of the things that's always interesting is a lot of lawyers are like, I wonder how this was a long time ago, and they read books. And one of the interesting things is a lot of lawyers are interested in history because Anglo-American law has always been pretty interested in history. It's always been interested in how things were in the past, why people thought something, and then how that has changed over time as the United States has changed.
Now, at the start of our conversation, you said something to the effect of, law is the history of the United States. And I wonder, how central do you think constitutional law is? How central is law to our identities and experiences as Americans?
Well, because for Americans, the Constitution over time began to loom so large as a system of government, and because state constitutions in some way are designed in conversation or imitation of the national or federal constitution, we imagine constitutional law to create the way we distribute power, who is allowed to have rights, how people participate in government. So we embody that constitution with an enormous amount of power. In some ways, when you get right down to it, most of our lives are led without having to deal with constitutional law at all. But when we get to the places where we have the most controversy as a nation, we tend to fall back on the Constitution as a way of arguing it. And over our history, the Constitution has been very important in repeatedly making sure that our government embodies a democratic world where everybody can participate. And what that has meant is over time, our Constitution has been expanded and interpreted expansively to increasingly allow everyone to participate. We frame that as a constitutional history or a constitutional conversation. Another country might frame it very differently.
The Bill of Rights, at one time noticed, was bound in a large volume, and it was bound at the top. And so if you look very closely at the very top, you see holes from the stitching. That's because at one point in time, GPO, which was the government printing office, put all amendments and acts of Congress into these large binders. The other thing to notice about the document is that at some point in time, it was folded, because you can see vertical and horizontal creases. Even though this document has laid flat for over 100 years, the creases are still very prevalent in the document.
Law is all around us. And so is the history of law. The history of law is the story of power, authority, and governance. And as Mary said, the history of American law is in many ways the history of the United States. Because the United States has always been a nation that frames its problems in terms of their legality. Now, this American practice of framing problems in terms of their legality goes back to the very founding of the United States. In 1776, law began to replace royal authority. And as it replaced royal authority, law became central to how the United States government operated and central to how we Americans began to understand ourselves culturally as a people. Now, if we want to understand American law, we must begin with the Constitution of 1787. This Constitution is the supreme law of the United States. As a nation, we embody the Constitution with an enormous amount of power. We give constitutional law, which is all the law that comes from the Constitution and its 27 amendments. We give constitutional law a lot of power because constitutional law is a law that distributes power. It's the law that determines who is allowed to have rights and how those who have rights can exercise those rights. It's because the Constitution and its amendments distribute power and determine who can have rights that Americans have always looked to the Constitution when questions of power and authority have arisen. Americans know that we have the power to adapt the Constitution to help us solve our questions, problems, and notions about law, democracy, and society. And this isn't a new idea or new knowledge. Americans have always seen the Constitution as adaptable and amendable. For example, in his famous McCulloch v. Maryland decision in 1819, Chief Justice John Marshall acknowledged and asserted that the Constitution is intended to endure for ages to come, and consequently, to be adapted to the various crises of human affairs. The Constitution is adaptable because the framers wrote it that way, and because we need the Constitution to be adaptable. So, how do we adapt the Constitution? Some of this work is done by us out in the world. We adapt the Constitution by the ways we think about and question our world. But a lot of this work is really done by lawyers and judges in courtrooms. Lawyers and judges interpret the Constitution. They interpret the Constitution by reading for its words, ideas, and intent. They look at the various statute laws Congress has passed to explicate and enforce the Constitution. They also try to understand how ideas about the Constitution and its applicability have changed over time and why those ideas have changed over time. Then, with all that in mind, lawyers and judges consider the present and make a case or argument for their interpretation. Now, if a case comes before the Supreme Court, the justices then consider the arguments the lawyers made, reference it with their knowledge and readings of the Constitution, and make a determination on the subject that the nation and its people must abide by. The study of change over time. Part of the work that lawyers and judges perform when they interpret the Constitution is the work of history. A large part of what makes the Constitution adaptable is the fact that it's a historic document that lawyers and judges consider historically in order to help the Constitution better serve us in the present. This is why, in the United States, history and the law are often intertwined. Okay, so now that we have a better idea that the basis of American law comes from the Constitution and its amendments, and now that we can better see some of the linkages between history and the law, we need to better understand how the history of United States law has developed and how history and the law work together to shape the laws around us. And that's what we're going to do over the next 3 episodes. In our next episode, we'll examine the Bill of Rights and how and why Congress drafted and asked the states to ratify it. In the following episode, we'll investigate the Fourth Amendment and how circumstances of the early American past and the British past helped give birth to it. Finally, we'll explore how the Fourth Amendment has influenced American law and how and why its influence has changed over time. Like history, law is all around us. And like all history, the history of law has a lot to tell us about who we are and how we came to be who we are. Look for more information about the National Archives, Mary Bilder, this new Doing History series, plus notes and links for everything we talked about today on the show notes page, benfranklinsworld.com/259. My Omohundro Institute Digital Projects teammates, Joseph Edelman and Holly White, have prepared some bonus materials for you so that you can take your exploration of American legal history and its origins even further. To accompany this episode, Joe has commissioned a blog post by Gautam Rao, who you may remember from episode 98 when we explored the origins of the American Customs Service. Well, as a scholar of American legal history and government, Gautam has written a post called Friends in All the Right Places, the Newest Legal History. I placed a link to Gautham's post in the show notes and in your Ben Franklin's World app. Now, Holly has prepared a couple of resources for you. First, she has created a reference list of all the legal terms we'll be using throughout this series. Now, we're going to do our best to keep these terms clear and discuss them as they come up, but we offer you this handy list just in case you want a reference guide. Second, Holly has also prepared a bibliography for you, a list of all the work we used to create this series, plus recommendations from our guest scholars. I've also placed links to this helpful glossary of legal terms and the bibliography in the show notes and in your Ben Franklin's World app. I'd really like to offer a special thank you to several people who helped make this episode possible. Jessie Kratz not only agreed to sit for an interview for this series, she also helped us gain 15 minutes in the Rotunda for the Charters of Freedom before it opened so we could record the segments you heard throughout this episode. Adam McNeil is a fellow historian and podcaster, and he helped me test out my recording equipment before I went to the National Archives. Now, as you heard, there were no glitches, so thanks, Adam. And if you haven't heard Adam McNeil's podcast work, please check it out. He's a host on the podcast New Books in African American History. Lindsay Travinsky is not only a historian, she's a wonderful hostess. Lindsay and her family hosted me for 2 nights so I could record in the National Archives. Please check out Lindsay's website, lindsaytravinsky.com, and learn more about her research on George Washington's cabinet. And as always, there is the invaluable production assistance provided by my teammates on the Omohundro Institute's digital projects team: Joseph Edelman, Martha Howard, Kayla Pittman, Holly White, and Karen Wolf. If you love our custom theme music, and I really do love it, please thank Breakmaster Cylinder. Finally, there are 10 amendments in the Bill of Rights, and we're going to focus on the 4th Amendment in this series. Still, I'd really love to know which amendment you find most valuable or most interesting. Or perhaps there's just an amendment that you'd really like to know more about. Tell me about the amendments that intrigue you. Liz@benfranklinsworld.com. Ben Franklin's World is a production of the Omohundro Institute.